Way a senior vice president of Imani Africa, Kofi Bentil, any NPA boss, Edudzi Tamakloe, and the Ako Boom TV3. Nina Sedina Tamakloe winning appeals case. And see, I'm going to say, Attorney General, at the case in the Supreme Court. Now, Kofi Bentil was a share before the Sedina Tamakloe, ye be extraditing Amana Bagana. No, a man for predicting. Na had say a man for prediction now boom. So, oh, Obabagana. Obe nibwa kushem kakra, obe file for appeal, obe wini appeal no, yebeko Supreme Court. Ni nyina bom no ehanu kakra. Na de be kase justice no, it must be seen say eye adwuma. Abusia, na Edudzi Tamakloe ewo show no so. Ana Edudzi Tamakloe say Kofi Bentil, sa argument we dey politics o. E wo so ma we chira hi agbamo na eye. Wo de wo ye lawyer ni, enti ya kasasa lawyer na me ho ni hunu say kasa twitwie. Abusia, and Kofi Bentil so want ase and boom clash for see you know. You both full video na ma no nya ho ase radio so kato show. Make sure subscribe we bell notification icon. Obetere on video no drop ya won sabeka. Feel free to leave your comment in the comment section. Obe share link na for fro and be. Lel Flower Green Clean Solutions that I say fie hospital, church, bank, institution, office, now per clinic company. I'm more press yes, home on a power when you remember how you come home about when you matter the Mr. Friend numbers negotiators. No, Kakrabi about Johnny, a church money you pull at the amount. Yet you can wear a just Ufra Crana Ubaku Master, just a traffic light, no, or try a pair on 75 about 1 2. I see our pair one sa ebekain. Back home assist, Abba Abusia for Uabuchi. Na say oye project bi Obabiko school na open eye in this country wo abrochire woni hanum say woni Ghana hanum say and the project na wo ye na brand ya open say unya real time updates fa ebdodum ye back home assist o the brain ya the ebe han say ye be ko site honum ya kwetwa pictures ya ma reports we a professional group and ye for adwuma ni agro enya abusu enya nnuan no de akodi agro na chenanko abeso bi di wasim dabi we a registered company ye adwuma di edi an say uni Ghana hanum say ye be your representative e Ghana hanum say bi bia person we Ghana ha ba uni hanti no o de friend numbers na go screens and say log into backhomeassist.com you be trade money you pull at the amount it's a building project abusia for obana wo school ba uni Ghana ha say you program na kwakosra no kwakosha na pomudin bibia school no connect say you be say background checks ni a final report kama pa the amount must spend the time chiro mu because who hear me and brother but who mo abuchi na mo complain pa say chale be the you be show be say Ghana ha say because won ko hwe kra wan ka no kra nchire back home assist oni yedi mpu a abusia sa problem nyina etu betwa abusia yankode nkote Kofi Bentil senior vice president Imani Africa me ba am the Edudzi Tamakloe response on Abel
all the charges and whether in their view all of the charges were so flawed as to not be upheld.
No, they're defective.
And I think they said from my reading it wasn't everything. They dealt with a few. And then it seemed they seem to have said that these charges, so many of them are defective, and then they proceed to clear the rest. I'm a bit worried about that. Even one charge is enough to put somebody in jail. And you see, we lawyers always say justice must be done, it must be seen to be done. If justice is done, it is seen. All right? And the same happens with injustice. And let me explain. So, before Sedina came to Ghana, there were people who predicted that in Chi we say Yakohu Abrewa, there's Sedina. The pressure for bringing Sedina back or effecting her extradition rose very high because they were going after Ken. And it was clear to many people that, well, to get Ken, they would have to bring Sedina. So people conjecture that they will bring Sedina. Because you don't do that, you can't get Ken. But if they bring Sedina, she will be sick when she comes. I'm saying these are conjectures that people make. And so she will not see a day in jail. You remember there was the whole issue of where is she? All right? And then they predicted that, Sedina will do an appeal. And then they predicted that there will be, a stay pending the appeal, and that the appeal is going to go Sedina's way. I think some of you heard some of these things. And that she will appeal, and they will exonerate her, and she will never see a day in jail. It is worrying, because I have said already that sometimes it seems as if the politicians have dreams, and they make wishes, and then the judiciary delivers it. Okay, one event is not a trend. So you don't create a trend on one event. But no wise person ignores a trend. It started with Justice Tokono. Statements were made before they even came into power. They come into power, something happens. Justice Tokono is gone. You had other situations, GN Bank. Okay, promises were made outside the courtroom. Okay, then somehow the judiciary delivers the dreams of the politicians.
Well, the Bank of Ghana is appealing that now.
Well, as we stand right now, see the trend? No wise person ignores a trend. Some politicians make statements to a certain effect, somehow, and then they go on appeal. Same thing happened with Sedina. Okay, people express something before the fact, and then it happens, and then they go on appeal, all right? And you see the series of nolli prosequis. Okay, there is a clear trend that the smart thing to do is, if you get in trouble, find a way to escape and wait for your political party to come into power, and they will clear you. We've seen the nolli prosequis. Nobody can deny there is a trend. Okay, we are being too hypocritical in Ghana, and I'm not saying people should be railroaded into jail when it's not due or whatever it is, but there's a man who liked chichinga, kebab, but one day he saw them slaughtering a cow. And he said, no, they shouldn't slaughter the cow. And they asked him, if you don't slaughter a cow, how will you get your chichinga? Look at Galamsey. We've been crying over decades over Galamsey that no kingpin has been caught or whatever it is. Then the government starts going after people, and one or two people get trapped in the thing. And then you hear all kinds of things. Look at this corruption thing we have been crying about. Okay. And honestly, if there is any benefit of doubt regarding judges, I will give them the benefit of the doubt. Okay. But we lawyers also know that you can argue any side of anything and rationalize anything. Okay. So when you put it all together, it doesn't look like we are serious about fighting this corruption thing, because nobody can convince me, after the work Manasseh did, after the evidence we saw. You go and buy something which on the street is 2 cedis. On the street is 2 cedis. And you alone, when you go and buy it, it comes up to be 4 cedis. And so many different things. The facts were clear. All right? And if even you had issues with some of these, the work of the prosecutor, like Richard is saying, we are not there to judge the work of the prosecutor, although they are important. I have said, okay, and I said it based on the Kenneth Ofori-Atta case and other things, that we need to look hard at the way our prosecutors proceed, because they mess up cases.
That the question is whether or not the state put up a good case. This 78 charges, was it more of a fishing expedition? Was it
I'm making a general point, and that's why
that's the issue that you're pointing to.
So I don't think anybody doubts that what went on in Maslock was untoward. And by the way, let me make this call. Abolish Maslock. Abolish Maslock. When they started, I remember some of these things that Imani says. They say we don't like anything, and then they will talk about ideology. I think it started during the MPP time. MPP set it up or something. And we said, look, you have all these banks and financial institutions and everything. Today they said they are going to start a women's bank. Okay. And the warning was that be careful about some of these things, because they can easily become slush funds. Maslock has become a slush fund. Look at the track. Okay. And invariably, more often than not, you hear about they giving loans to political operatives, and they don't recover those loans, and then we end up having problems. So there's another trend there. But the thing is, where there is a crime, or there is, the suggestion that there's been a crime, as was obvious in this case, our prosecutors must be careful. Because my point in the case of Kenneth Ofori-Atta was that the way they have gone about it, even if the man was guilty, you are going to let him loose. So please, it's coming up here again. All right. However, if you look at section 406 of Act 30, okay, it clearly brings to question what the justices of the appeal court did. Okay. And 406 generally talks about substance and not form. That you don't just throw out everything because there were errors in certain things, and it doesn't go to the substance And in one of the statements, I kind of gleaned that the justices were making the suggestion that it goes to the substance. And I was looking for where it goes to the substance. And I didn't see it. So for you to say they did a sloppy job and the job was so sloppy that the crime didn't happen. Okay. I think that if you flip the other side, yes, they have to prove beyond reasonable doubt. But for you to also take it up and throw everything away, you have to prove, at least to reasonable people, that everything that was done was wrong. Look, one charge alone is enough to put a person in jail. Okay, so to suggest, and by the way, she has been acquitted and discharged. Okay,
which means that any other
charge
is completely
okay.
out.
Now, if you put all of, I said, don't ignore a trend. If you put the sweepiness of the action, everything gone. If you put some of the things that were done, it looks like somebody wanted to just free Sedina. And then you connect it to the things that were said before she came. You ask yourself, where are we going with this corruption thing? Let's see how the appeal will go. But I can tell you something here. I don't think that appeal is going to go anywhere.
You don't think the appeal will go anywhere?
I don't think so.
The Attorney General is convinced. He says that, look, he sees merit in some of the charges. And the reason why he's going to court. And on the grounds of appeal, listen to the language of that notice of appeal in the state.
And Senior Vice President of Imani Africa, Kofi Bentil in Karabusia, the second is said, hey, Edudzi Tamakloe. Edudzi Tamakloe sama sa ono kasa tsela ya niu. Edi Kofi Bentil sua bibi free. Nye bibia na we nkwanche argument. Na me say clash bi esi en e wakakra bata mi kuchi na kwhwema ni si na nya ho nti ase.
So Alfred, first of all, I listened to my senior Martin Kpebu. I listened to the other two. And I have no doubt at all that this morning, my learned senior Kofi Bentil decided not to do law, but politics.
Why is that?
And the reason why he decided not to do law, but politics, is that with all his learning of the law, it would be extremely difficult for him to undermine this judgment. And so conveniently, he chose the path of politics instead of law. But our training is law. The politics is just an addition, regrettably. This morning, my learned senior pontificates very strange legal propositions. One is that an American court can have a say on criminal charges filed in a Ghanaian court yet to be determined. Where from this learning, Bentil?
Do you want me to answer?
No.
You don't want me to answer?
No.
Then no, that question is wrong.
Because
wrong question.
The American court does not have supervisory jurisdiction over the Ghanaian court.
Nobody is saying that. When you ask them to extradite somebody, you brought me in. You ask them to extradite somebody. You effectively ask them to look at what you are doing, and they judge it. They said you don't look serious.
Can I proceed?
So don't be me. I have to respond.
As we speak, there is no decision on extradition in respect of Ken Ofori-Atta. Ken Ofori-Atta requested for permanent U.S. residency, among others, and he went before an immigration court. It is that immigration court that had given a decision. There's no question whether Ken can be extradited or not. So what are you talking about?
Nobody is saying that.
The request for extradition by the Republic is yet to be decided. So please don't mislead the public.
Right.
We owe it a duty.
He should make his point.
Right. Look, you see, I have seen a wayward American judge who decided to engage in judicial waywardness by pronouncing on criminal charges filed in a Ghanaian court, yet to be decided. Today, as we speak, the United States of America is fighting even the International Criminal Court.
Yes.
Yeah.
Even the International Criminal Court, Secretary of State Rubio, Marco Rubio, is saying that the judges there are lunatics. And you have a Ghanaian lawyer. Please, let us not sell our sovereignty for people.
When you extradited people without proper process.
Now let me deal with the substantive matter. First of all, we are being told that when a charge sheet is defective, that defectiveness should be overlooked. Proceed. My Lord Justice Pega, in his validatory judgment, Osekwejo II and the Republic, said the provision you read relates to Act 30. However, the 1992 Constitution has raised particularity relative to charge sheet to a constitutional pedestal. Article 19, 1D. And for that matter, where particulars are defective, you cannot use evidence to cure that defect. And so if you look, Sedi had 2 appeals. When prosecution called its 6 witnesses, the prosecution said they have closed their case. A submission of no case was done. One of the issues Sedi raised right from the beginning had to do with the defectiveness of the charge. The High Court judge said, proceed and answer the charges. That submission of no case was appealed against. And if you read the notice of appeal and the grounds in respect of the submission of no case, included the fact that, included the fact that one of it clearly had to do with the defective charge sheet. So it is in the notice of appeal.
The 2024 one?
Yes. And no, so the first appeal was August 2023. That was when she was called to open her defense. But then they raised that issue. Now, when the judgment was delivered in May 2024, if you look at the notice of appeal filed on the 9th of May 2024, in that notice is the omnibus ground. Which omnibus ground is the fact that the judgment is unreasonable, having regards to the evidence on record. All of us lawyers here seated know that once that omnibus grounds of appeal is raised, the entire proceeding is subject to review. And that is why we say appeal is by way of what? Rehearing. It means that everything that happened at the trial court, the appellate court is put in that position. Obviously, they don't have the benefit of assessing demeanors. Because the trial court is the only one that gets the opportunity to see witnesses and others. The appellate, they are just going to look at just the record without more. Now, I have heard the former Attorney General, the former persecutor, say that the notice of appeal was not brought to his attention.
Yes.
Yeah, yes.
Can you imagine? Clearly, it shows you that the guy was sleeping on the job.
Well, this is the part of the statement. He says, no notice of an appeal filed by Sedina in 2024 came to the attention of the Office of the Attorney General in my tenure.
Please, hold on. I've read the statement.
And deal with the records too.
Please, I've read the statement.
The records were not also filed.
I'll deal with it. You see, Kofi, you're a lawyer. Don't do this.
Hey, Master.
Senior.
Bring me in. I'll
No,
defend myself.
yes, you will. But my point is that as lawyers, there's a bigger standard placed on us. With the greatest of respect to you, you can't speak like Anyaba. He's a politician. He is permitted to express any opinion, anyhow. Desirable. But you, a standard is placed on you. You cannot sacrifice that standard on the altar of political expediency. Why do I say so? On the 9th of May 2024, the notice of appeal was filed at the registry of the High Court. Whose permission or duty is it to serve that notice? Sedi? 2. The point had been made that pieces of the records were even missing. Look, I have with me the decision of the Court of Appeal differently constituted, because the Attorney General brought an application before the Court of Appeal for ratification of the record. Is that not the procedure that the rules permit when you have issues about the records? Is to apply for ratification. The Attorney General applied to the Court of Appeal, presided over by Justices Georgina Dacha, Amedahe, and another one, who reviewed, in fact, said these lawyers opposed the application on the grounds that the very document they claimed were missing are documents that the prosecution itself disclosed to them. And so for that matter, you cannot be saying that your own document is missing from the record. Said these lawyers oppose it. The Court of Appeal looked at the two sides and came to the conclusion that regardless of the fact, your claim that the prosecution has it already, our decision is that the records ought to be done again. And those documents submitted to the Attorney General. Are you aware of that? And so what have you decided to do? Bandy misleading information to cheer up your supporters who have lost an election. Said it's not the reason why you lost your election, a devastating election. Said it's not the reason. Now there are substantive matters. First of all, the counts were 78. The defective counts were even less than 10. The rest of the charges were evaluated on their merits. You did a shoddy work, poor work. Godfrey supervised the poor work.
That's why he doesn't disagree with you.
And you know why? He never took his work serious.
What do you mean by that?
Yes. And I'll tell you. And you see, sometimes when I listen to Godfrey, I say, look.
I beg, the man is not here. Stop.
So,
but the statement he issued, what do you think he was doing? This is an innocent person that he seeks to attack and destroy.
Who is the innocent person he's attacking?
Oh.
The man is AG doing his work. If he's here, he will defend himself.
Kofi,
but I am complaining.
Yeah,
So let him finish. No.
Let me make my point. Let me make my point. I'm listening to him.
So are you referencing the statement he
Yes,
made?
the statement he made.
The
I'm not permitted. Who issued the statement?
No, you deal with the statement.
No, Kofi, who issued the statement? What is this trying? Imagine if it's found that there was no notice of appeal. Do you know what Godfrey would have succeeded in doing? Is to undermine even the judges. Why would you have entertained an appeal when there is no notice of appeal?
Are you referencing this particular document?
See the date, 9th. Where is it? The registry of the High Court. 9th May 2024. Signed, High Court Accra. This is fictitious, shameful. And you think this person should be taken serious? And you see the painful part of this conversation is that, and like I said, this is not one who. In the Atofose matter, the same shoddy work was done by him. What happened? The same High Court judge says the burden was shifted on Atofose. Look, I've always maintained the only work I would do permanent is to be a lawyer. It's to be a lawyer.
Petrol. Right now you sell petrol.
That's why I say permanent. This one is not chieftaincy title. I will leave it. You understand? So I have always been cautious in dealing with legal matters, particularly those that borders on the liberty of an individual. The liberty. You have a situation where the justices of the Court of Appeal had the opportunity of evaluating. And look, I am not surprised. Look, when the Court of Appeal acquitted and discharged Atofose, go and look at Godfrey's statement he issued immediately. Was to attack the justices of the Court of Appeal. That's him.
Because it didn't go in.
Because it didn't go his way. This is an attorney general who today, a former attorney general who today, the disciplinary committee of the General Legal Council had found a prima facie case of professional misconduct against him.
He says the Republic
When was the last time you saw
to do.
this happen?
Said the Republic had nothing to do in this 2024 matter in terms of the conduct of that appeal.
Look, let me just go
That's
ahead.
what he references.
The office of the Attorney General does not belong to Godfrey Dame. It is an office that continues. The state prosecutor on record, if you read the judgment, the Court of Appeal judgment, you have it.
Yes.
There's a named individual there, Hilda Craig. She was part of the people who prosecuted the case before the High Court. She handled the appeal and a different outcome. Unless, of course, my friend here, and listening to Ahiagba has, won't me file the notice of appeal?
I know that the process underway. I don't know if they're found.
Yes, this was
So
on
the understanding I get
Monday
from
or
you
Tuesday.
is that you expect only one outcome from the Court of Appeal, a dismissal of the appeal.
No, not exactly. I didn't say that. I didn't suggest that.
You didn't know why I asked you that question.
Well, I didn't suggest that. so-
Think through my question.
Think about what Martin said earlier. Before you answer.
But you see, I asked you this question for an obvious reason.
So that is a blackmail question that you're asking.
It's a trick question.
Yeah, it's a blackmail question.
You see,
What's the point?
you see, the point I am making is that, Alfred, I've heard people who have not even read the judgment pontificate on it. Yeah. This morning, when I listened to my learned senior,
Your learned senior Martin says,
no, you.
Your
I'm
learned
coming.
Martin says,
I'm coming.
listen to him
You
too.
would stay calm.
Rehearing was the normal
Kofi.
outcome of this.
Kofi, listen to me. Listen.
on your philosophy.
Listen. No, what philosophy?
learned
He is
senior,
not
you
even.
listen to him.
My point is that, Kofi, with the greatest of respect to you, you have not exhausted this judgment. You have not. I've listened to you, and you have not. And you have
Tell
not.
me where.
You have not, because if you read this judgment, it will expose your prejudices.
So, where exactly?
What
are you
I've
talking
read
about?
confirms what I've said.
You see,
But you have not read all.
please, the defective
himself
charges,
hasn't read
the
it.
defective charges, for instance, count 45, conspiracy to commit crime, namely, willfully causing financial loss to the state, contrary to section so and so. Now listen to the particulars. Sedina Christian Tamakloe Tiono, Daniel Axim, April 2016, in Accra, in the Greater Accra region, agreed to act together with a common purpose to willfully cause financial loss to the state. That's it. Kofi, you read
What's your
criminal
point?
procedure.
Point.
We both did criminal procedure, because without it, you won't be a lawyer. Is that how you put a criminal charge?
Martin is an authority in criminal law. He says the point here, if you read everything.
Martin never said that.
said it's an
Martin,
He is not saying, I am saying.
Please stop.
I am saying he's an authority in that. He says the natural conclusion. I agree with him. That's what I'm saying. So.
Hold on.
He's an authority. Martin is an authority.
Because
they study him in criminal.
please.
You bring me in, I'll answer you. He said rehearing is the normal thing that you should have expected in this case.
Because
You should stay on his case.
if you
and stop following.
read the counts, a count should be an invitation to offer a defense. So the count must contain an act or omission. Where is it here?
You are wrong.
So please, why am I?
No,
wait,
Mr. Bentil,
for the public's sake.
Why
I'll come to
public
you. We
sake?
just noted.
That count is not an invitation to offer a defense.
Oh my
A count is a statement that the prosecution must
Mr.
prove.
Bentil.
Oh,
Mr. Bentil.
you see, you don't even know what you are talking about. Senior.
Okay, no
So
problem.
if you
So
look
easy. Yes.
in the Republic versus Ernest Thompson challenged the charges that were brought against him. The High Court dismissed it. He said the charges were defective. It went to the Court of Appeal. He further appealed to the Supreme Court. I invite you to read my Lord Justice Tanko's reasoning. My Lord Justice Tanko took the view that the charge must contain a certain level of sufficiency to meet a constitutional threshold. The lack of it is not cured by amendment. you strike it out. Now, on appeal, if you strike a charge out, everything found on it will collapse. So it is not the charge sheet that was struck out, but specific counts. Those counts that meet the constitutional threshold were allowed to stand. Now, what the judges did, what the judges then did, was now go into the merit, the specific merit of those counts. My senior, what's the name, Martin, raised a very interesting point. Which interesting point had to do with the specifics, the counts. He's done an extremely good job on it. If you pick, for instance, the one bordering on causing financial loss to the states, about the buses, okay? The buses that were...
But for GPRTU?
Were bought 350 buses.
Somebody commits a crime.
Your challenge was that
somebody pays.
He had committed causing financial loss to the state. In the charge of causing financial loss, the fundamental thing that you have to establish is that, in fact, the person authorized payment. Because without it, the charge will not succeed. It is not a charge that is left hanging. The charge must found factual basis. So the justice of the Court of Appeal reasoned otherwise and said, your charge is that A, B, C, D was not done, for which reason you are charging the appellant. By your own prosecution, and guess who the first prosecution witness was? The current MP for Ishiaso, Sticker. He was the first prosecution witness. Now, guess what happened under cross-examination of Mr.
Stephen Amwa. Dr.
I always still call him Sticker.
Dr. Stephen Amwa.
Exactly. Under cross-examination, lawyers for Sedi asked him a very specific question. And also the Director of Finance was brought in as the fifth prosecution witness, the Director of Finance of Maslock. So the question was put to him. I'm trying to retrieve that particular portion. Because you see, Alfred, I think that people need to see what is on record. When you see what is on record, if you can still, in the face of those evidence or pieces of evidence on record, still come to a different conclusion, then yours is just not a question of law, but you are looking at something else. Alfred, permit me to read it.
On where exactly? So that, while we flip through.
No, I'm going to the records, the records of proceedings. Sticker. Okay. PW1. You will see his testimony at page 80 of volume 3 of the record of appeal. Page 80 of volume 3 of the records. Question. You also know from your records that the contract for the acquisition of the vehicles had been signed by your predecessor, but not a single cedi had been paid by Maslock. Is that correct? Answer, yes, my lady. That's Sticker.
That no payments were made?
Yes. Now, at page 294 of volume 3 of the records of proceedings, PW5, the Director of Finance of Maslock, under cross-examination. Question. Your CEO has testified in this court that they renegotiated the entire contract price. Is that the case? Answer. Unfortunately, I cannot speak on my CEO's testimony. Question. I'm asking you personally. Maslock says that the contract price was renegotiated. Is that the case? Answer. From what the person gave to me, yes. This is prosecution witnesses. Now again, at page 297, 294 of volume 3 of the records, question, the same Director of Finance. This renegotiated contract was done for how many years after A1 had left office? Answer, I have no idea. Prosecuting witnesses. Question, but you will be able to tell the court when the payment was made. Is that correct? Answer, yes.
Edudzi Tamakloe first response on the ma Kofi Bentil na buza for me the Abraham Radio so katwa show. Me the program ni esi enche bia na janto amobete nka radio so katwa show. Mo so for Steve Zando ni message me di shebu bi enche kra. Bye bye.